Friends, welcome to WordsQ. Today we are going to see what are the rights and the duties of the buyer or the allottee under the Real Estate Regulation and Development Act 2016. So as a buyer, it is very important to understand what are the rights and duties has been given to you under RERA. So let's move ahead and see what are the rights of the buyer and allottees under the RERA. The first is section 19 provides for the various rights of the allottees, or you can say buyer under RERA. So the first section says that the section specifies the various rights which the allottee have against the promoters, including those which the promoters are liable to fulfill based on the agreement entered into with the allottee. So there are two kinds of rights, that first he gets as per agreement with the promoter, and second as a buyer under the RERA. So namely the first one, the rights he has is stage-wise schedule of completion of the project. He has a right to get the information, claim timely possession of the apartment, plot, entitlement to necessary document and plan, etc. Then further rights under section 19(1), it says that the allottee shall be entitled to obtain the information relating to sanction plan, plan layout, plan along with the specification approved by the competent authority, and such other information as provided in this section, act, or the rules or regulation made thereunder, or the agreement for the sale signed with the promoters. So whatever details are mentioned there, he is eligible and has the right to get the information under those sections. Moving ahead, under section 19(2), the buyer or the allottee shall be entitled to know the stage-wise time schedule of completion of the project, including the provision for water, sanitation, electricity and other amenities, etc., and services as agreed to between the promoter and the allottee in accordance with the terms and conditions of the agreement for sale. Let's move ahead and see what other rights are there under section 19(3). It says that the allottee shall be entitled to claim the possession of apartment, plot or building as the case may be, and the association of allottee, or you can say society, like we generally says housing society or any other association of allottee, shall be entitled to claim the possession of the common areas as per declaration given by the promoter under subclause C of clause 1 of subsection 2 of section 4, that is defined by the common area as per RERA Act. Let's move ahead and see what are the provisions of section 19(4), and it says that the allottee shall be entitled to claim the refund of amount paid along with the interest at such rate as may be prescribed, and compensation in the manner as provided under RERA from the promoter if promoter fails to fulfill his liability. If the promoter fails to comply, unable to give possession of the apartment, plot or building as the case may be in accordance with the terms of agreement for sale, or due to discontinuation of his business as a developer on account of suspension or revocation of the registration of promoter under the provision of this act. So if promoter is debarred from any registration as under RERA, then in that case he will refund the amount to allottees along with interest and will pay the amount to allottee under section 19(4). Let's move ahead and see under section 19(5), and there is the allottee shall be entitled to have the necessary document and plans, including that of common area, after handing over the physical possession of the apartment or plot or the building as the case may be by the promoter. Now, apart from the rights, the RERA also gives some duties to the allottee or the buyer, and that buyer need to make sure that he fulfill his duty or obligation under RERA. What are those obligations? Let's look ahead. And section 19 itself provide for those duties also, and which provide for the matter relating to payment regarding apartment or plot, and liability towards the interest for delay in payment, and the responsibility to take the possession, etc., and also to participate in formation of association. So that is the broad level obligation that the RERA places on the allottee, while it also places the liability on the promoters. Let's move ahead and see what section 19(6) says about the duties of the allottee, and it says that every allottee who has entered into an agreement for the sale to take an apartment, plot or building as the case may be under section 13 shall be responsible to make necessary payment and the manner with the time, so it will be as agreed terms as per agreement for sale in the said agreement for sale, and shall pay at the proper time, place and share the registration charges, municipal taxes, water and electricity charges, maintenance charges, ground rent and other charges as per agreed terms to the promoter. Section 19 subsection 7 says that the allottee shall be liable to pay interest at such rate as may be prescribed for any delay in payment towards an amount of charges to be paid under subsection 6, that is section 19(6). Then it further says that under section 19(8) the obligation of allottee under subsection 6 and the liability towards interest payment under subsection 7 may be reduced when mutually agreed between the promoter and such allottee. So it makes it legal to reduce the charge, the liability of the allottee or the buyer under section 19 subsection 8. Under section 19 subsection 9 it says that every allottee of the apartment or the plot or building as the case may be shall be participate towards the formation of an association or society or a cooperative society of the allottee or a federation of the same. Section 19(10) says that every allottee shall take the physical possession of the apartment, plot or building as the case may be within a period of 2 months of the occupancy certificate issued for the said apartment, plot or building. So it is an obligation placed on the buyer or a allottee under RERA. Under section 19(11) it says that every allottee shall participate towards registration of the conveyance deed of the apartment, plot, building as the case may be as provided in the subsection 1 of section 17 of this act, where the conveyance deed need to be executed between promoter and allottee. If you like our video and if you like the information that we shared, then please click on the subscribe button and keep watching What's Q for more video and stay updated. Thank you.